All right, welcome to the video on intellectual property. This video will provide you with an overview of the field in general. It's a very brief summary just to give you a flavor of what this body of law entails. We've already looked at the Fifth Amendment, which has two protections for property, right? Due process and just compensation. What process is somebody entitled to before the government can deprive them of their property? And when does the government have to pay just compensation for that deprivation of property? In general, property law is state law. The state decides what is property, and then the federal Constitution places those outside parameters on government action vis-a-vis that property, right? What has to happen before you can be deprived of your property, except for intellectual property. Here, in Article 1, Section 8, Clause 8, the Constitution affirmatively directs that Congress shall have the power to promote the progress of science and useful arts, and to do that by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. In other words, this provision directs Congress to create property rights of some kind, though the contours are left unspecified. And as we think about intellectual property, I want to encourage you to keep an eye on the purpose that the Constitution says intellectual property serves: promoting the progress of science and useful arts. Right? Intellectual property is a means to an end. It is a way to promote the progress of science and useful arts. There are three basic types of intellectual property, and we're going to walk through all of them: patents, copyright, and trademarks. Here, they are demonstrated through jelly beans. On the left, you see the patent applications. First, on the bottom, for actual jelly beans, patented in 1885. And then above that, you see a figure for a machine to make jelly beans. On the right, on the bottom, you see Mona Lisa made out of jelly beans. That is a work of art that obviously Mona Lisa is a pre-existing work of art, is a work of art in the public domain. And this representation via jelly beans is a derivative work of art that is entitled to protection. On the right, you see a Jelly Bean Friends coloring book. This is a book that is themed around jelly beans. This book is also entitled to copyright protection. And then above it, you see a trademark, the logo of the Jelly Belly Company, and that is entitled to protection as a trademark. So let's start with patents. Patents are governed entirely by federal law. There are three requirements in order to get a patent. You must demonstrate that your invention, first of all, you get a patent for an invention. In order to get a patent, you must demonstrate novelty, that your patent has some kind of an inventive step that takes it further than the prior art. You must also show that your invention is useful in some fashion, and the utility threshold is very low. That should say 2, not 3, apologies. And then the third thing you have to show in order to get a patent is that not only is there an inventive step and it is useful, but that it is not obvious based on the inventive step. Again, that is a pretty low threshold, the non-obvious threshold. If you obtain a patent, what you get are exclusive rights to use and exploit for 20 years. In exchange for that right, because remember, this is about promoting the useful arts and sciences, in exchange for that patent, that exclusive right to use and exploit for 20 years, the patent holder must provide the patent office with a written description of the patent with sufficient detail that would allow somebody else to understand what you have done. Drugs are patented, among other things. Most things that we think of as physical inventions in the world can be patented. Now, you may have seen this logo on the right, patent pending, on something. So the term patent pending is a temporary status granted to a product or process that is in the preliminary stages of a full patent application, because a patent application can take a while. It doesn't provide any legal protection in and of itself, but it allows an inventor to officially lay claim to the idea that they are, the concept of the thing that they're trying to patent. And so why might somebody file this? Just having patent pending on your widget, your thing, might dissuade a potential imitator from attempting to make it on their own and thereby maybe stealing your intellectual property, while simultaneously it encourages applicants to move forward with their full claim in a timely fashion. So while a patent is pending, there's nothing to legally stop anyone from potentially using and profiting from the idea. But if the patent is ultimately granted, the patent protection it confers is retroactive, backdated to the time of the provisional filing. And that's why it sort of is an incentive for other people to not copy, because they know, right, they have notice, they are on notice that their actions, if it is in fact profitable, may subject them to future litigation if the patent is granted, at which point the patent holder might try to get that infringer to disgorge profits. Okay, so let's talk about copyright. Copyright is governed by federal law and by a series of international agreements that the United States has entered into with other countries about how copyright will be protected. In order to obtain a copyright, you have to demonstrate originality, and it has to be a work of authorship, and it has to be fixed in a medium. Now, the important thing to remember is that you cannot copyright an idea. Copyright protects the expression of an idea that is fixed in a medium. And, Thomas Jefferson perhaps said it best, and this is a quote: "If nature had made any one thing less susceptible than all others of exclusive property, it is the action of the thinking power called an idea, which an individual may exclusively possess as long as he keeps it to himself. But the moment it is divulged, it forces itself into the possession of everyone, and the receiver cannot dispossess himself of it. Its peculiar character, too, is that no one possesses the less because every other possesses the whole of it." That last part, that's the unquote, end of the quote. That last part is expressing the idea that this is an idea is a non-rivalrous good, meaning that multiple people can use it at the same time with no diminishment of their use. For example, if I buy a book, right, I can read that book. I have a physical copy. That doesn't stop someone else from also reading another copy of the book at the same time, either another physical copy or an e-version of it. By purchasing the book, I have purchased that copy. I own that copy. It is my property in the ways we've been talking about in class. Right? I have many sticks in the bundle. I can read it, meaning I can use it. I can give it to a friend. I could resell it on eBay. I could destroy it. Right? I could spill coffee on it. I could rip it up. I could burn it. I own that copy. But I don't own the underlying story. The author owns that for the duration of the copyright. This is a cartoon from Puck magazine in 1886, and it is a commentary on the state of copyright laws at that time. At that time, copyright law did not offer protection to foreign authors and works. And that was why the first convention on copyright, the Berne Convention, was negotiated, came into force in 1886. 1887. And what you see here are American authors on the left, most notably perhaps Mark Twain, and British authors on the right, including poets Tennyson and Browning, right? And Jules Verne, right? All yelling at the publisher who Puck Magazine characterized as a pirate, because they could take somebody's work, say Mark Twain's work that was published in the United States and protected by copyright in the United States, and they could publish it in Europe and not have to pay the copyright holder anything, before the Berne Convention, which negotiated how states were going to harmonize their copyright laws and ensure that authors were protected. So the first copyright statute was in 1710. The British Parliament enacted what was called the Statute of Anne to address the concerns of English booksellers and printers. This 1710 Act established the principle of authors' ownership of copyright and fixed a term of protection of the copyrighted works that was 14 years and renewable for 14 more years if the author was alive at the expiration. The statute prevented a monopoly on the part of booksellers and created a public domain for literature by limiting the terms of copyright and ensuring that once a work was purchased, the copyright owner no longer had control over its use. Going back to my example of me purchasing a particular copy of a book. But it wasn't until the 1886 Berne Convention that there was mutual recognition of copyright between sovereign nations. Today, a work that is created after January 1st, 1978, copyright protection lasts for the life of the author plus an additional 70 years. For an anonymous work, a work published under a pseudonym, I can't say the other word, and a work made for hire, meaning that it is made under a contract with an employer, a copyright lasts 95 years from its first publication or 120 years from its creation, whichever expires first. Now, I want to emphasize again that this cartoon, right, is calling the publishers a pirate. That is something we have seen before. The idea of piracy comes to us from admiralty law, right? A pirate is a ship that is not under the control of a flag state. It has no sovereign. And because piracy poses a peril shared by all vessels and mariners of all nations, it is considered a crime upon all nations. As a result, those engaging in piracy hold a particular status shared with foxes, a la Pearson v. Post, of the enemy of humanity. Since piracy anywhere is a peril to every mariner and ship everywhere, there is a universal right and duty of all nations, regardless of whether their ships have been beset by the particular bands of pirates in question, to capture, try, and punish pirates. So pirates are subject to universal jurisdiction. And what we see on the right, is again this idea that copyrights will protect you from pirates, from those who are lawless, the enemy of humanity who will steal from you. New technologies bring new challenges to property rights, particularly to intellectual property rights. What you see here is a illegal, online way to purchase or to download for free audio, video applications and games, things that are protected by copyright. And notice this asks you to pay with cryptocurrency. Napster was a much earlier example of this. It was offered the possibility for people to share files electronically of copyrighted material. And it was a real crisis for intellectual property, because new technology creates new issues for ownership, especially of intellectual property. Issues today, like that are really hot button issues right now, include the use of generative AI in entertainment, scanning actors, for example, and using their images in film, and or the Anthropic litigation that we have mentioned on a couple of occasions, where Anthropic trained its AI Claude on the copyrighted works of thousands upon thousands of authors without their permission or without paying them anything for the use of their copyrighted materials. These are questions that will be worked out in the future. Obviously, Anthropic has settled that lawsuit, and after they were faced with the prospect of losing in court. So this is a chart of, at a particular point in time that I think was a couple months ago, I don't remember exactly when I grabbed this, of all of the copyright litigation against generative AI companies. And the issue in that litigation is what constitutes fair use of copyrighted material. Because unlike patents, where the owner has the exclusive right to use and exploit, copyright, right, has some limitations. And the biggest limitation is fair use. Me showing you this slide is fair use, right? Notice I've credited where it came from, and because I am using it in an educational setting and with attribution, right? This is fair use of that copyrighted material. And so the argument in the Anthropic litigation was their use of the copyrighted material to train their AI fair use or piracy? Every year, Duke University puts together this great chart of Public Domain Day, indicating all of the works for which or not all of the works, some of the most famous works for which the copyright has expired. Here you can see, actually you can't see because this, for some reason it's showing too big. At the bottom, Murder at the Vicarage, Agatha Christie, right? Agatha Christie's first book is now in the public domain. The Nancy Drew mystery, Secret of the Old Clock. In the center, you might notice there's Goofy and Betty Boop. And the movie All Quiet on the Western Front, a Marx Brother movie, and you can see Mickey and Minnie. Parts, more and more of Mickey and Minnie are getting into the public domain. The book As I Lay Dying by Faulkner. When works go into the public domain, they are no longer protected by copyright. They can legally be shared without any permission or fee. Community theaters can screen the films. Youth orchestras can perform the music publicly without paying any licensing fees. Online repositories like the Internet Archive, the Hathi Trust, or Google Books, and the New York Public Library also has one, can make the work fully available online to anyone. Right? This helps enable both access to and preservation of cultural materials that might otherwise be lost to history. So anything that was published before 1930 is now in the public domain. 1930 was a long time ago, and the vast majority of works from that year are not commercially available right now. Some of the ones I pointed out on this chart are, right? Obviously, The Murder in the Vicarage is, Animal Crackers is. But for most of the works from 1930 and before, you can't buy them or even find them if you wanted to. When they enter the public domain in 2026, though, anyone can rescue those works from obscurity and make them available, can make them available for free, or can even sell copies on, say, Amazon. Make them available, we can all enjoy, discover, and breathe new life into them. Notice Pluto, as I pointed out earlier, Pluto and Betty Boop in the center. In 2024, the first image of Mickey Mouse from the 1928 film Steamboat Willie entered the public domain. Anyone can show that film now without Disney's permission, and Disney is really notorious for being super stringent with its in protecting its intellectual property. In fact, there are cases of them suing elementary schools that showed, like the mermaid movie, I can't think of what it's called, without permission, without paying a licensing fee. So now for Steamboat Willie, and you see, right, Mickey and Minnie with their trademark white gloves, they are also in the public domain. Now, what Disney did to respond to this was to incorporate Steamboat Willie into the Disney trademark. Trademarks never expire. We'll look at those in a minute, so long as it is maintained, which means you have to file paperwork and you have to actually use it. Where copyright prevents unauthorized copying of a specific creation, trademark is about customer confusion. It protects a company's mark to provide customers with assurance about the source and quality of a particular creation. So boiled down, now that Steamboat Willie is part of Disney's trademark, any public domain use of it or the original Mickey or these Mickeys cannot be perceived as coming from Disney. The other thing that can happen when something is in the public domain is that anybody can make a derivative work. This is an example of a derivative work of Winnie the Pooh. Winnie the Pooh is in the public domain, and anything in the public domain can be freely used in any fashion. And as you might imagine, neither a Milne nor his estate nor Disney, which purchased Winnie the Pooh, would have authorized this horror film about blood and honey. Just offer it as an example. So let's talk about trademarks. In order to get a trademark, right, the would-be trademark holder must demonstrate that their mark is distinctive, it is non-functional, and that they are the first to use it in trade, right? A trademark is a mark that is supposed to represent your company. And again, protecting trademarks focuses on the possibility of customer confusion. The test is whether the product is likely to cause confusion among the relevant public. Anything that is generic or anything that is merely descriptive cannot be registered as a trademark. Trademarks are really valuable, or can be really valuable. Here are some trademarks. Perhaps you recognize them and recognize the companies that they represent. Google's trademark is worth about $44 billion or more. Apple's trademark is worth even more. About the last estimate I saw was about $98 billion, according to their SEC filings. So this is big money, and companies are vigilant in protecting or trying to protect their trademarks. So my question is, would these confuse you? Does it matter? In 2019, Starbucks ranked number 31 in the world for the value of its trademark. And that was the latest data I could find. And I already told you about Google, right? Coca-Cola values its trademark at $36 billion. So, right, so the test for trademark infringement is customer confusion. So the question is, would these marks confuse you? Stars Coffee, right? That one looks pretty close. Starbung Coffee, Stars and Bucks Coffee, right? Star Prea Coffee. What about these? What about this one? Would this one confuse you? And then the question is, why would Starbucks care? There are a couple of reasons that Starbucks might really care, especially about the Starbuds flower one, because that's associating their mark with something that is illegal in many states, right? And is a drug that is on the federal list of illegal drugs. So, right, there's damage to their reputation in general, but also these fake marks might represent lost sales to people who were thinking they were buying Starbucks coffee. It's a dilution of their trademark, associations that Starbucks didn't pick. And if anybody can use this logo, it could become generic and then it wouldn't be their trademark anymore. So, but I just want to point out that Starbucks is also drawing on the public domain as well as having a trademark here. Right, going back to Moby Dick, Starbuck is the first mate of the Pequod, which is the ship that Captain Ahab sails as he chases Moby Dick. And Starbuck sort of operates as the voice of reason aboard the ship. He's a Quaker and periodically brings a religious perspective to some of the arguments that take place during the ship's journeys. And the name, both here and in Battlestar Galactica, was an intentional evocation of that literature. So Starbucks is also pretty litigious and vigilant in protecting their trademark. In 2018, the company on the left, called Mountains and Mermaids, it was a small business owned by a mom and a daughter, filed a trademark application for Siren's Brew in connection with coffee beans and ground coffee. Starbucks intervened in the trademark application, opposing the registration based on a likelihood of confusion between the Starbucks logo and M&M's Siren Mermaid's Brew mark. The trademark board sustained the Starbucks opposition and refused to grant the Siren's Brew mark for the coffee beans and ground coffee on the ground that it created a likelihood of confusion with Starbucks design logo. And Starbucks filed suit in 2024 in the Southern District of New York to enjoin Mountains and Mermaids from selling Siren's Brew and to require that they destroy all material using that name or containing that mark. Last I checked, they're still selling some stuff. So I don't know if they reached an out-of-court settlement or Starbucks doesn't think it's worthwhile to pursue this small business any further now that they've made their point, or maybe they have closed it, right? They announced, we will sadly be discontinuing our Siren's Brew design because of this litigation, but it seems to still be for sale. So this is a photo from a dispensary that I went to in Michigan. None of this is snack food. It's edibles. I just want to point out the Trips Ahoy there. Now, the question is, and these are Cheetos Chunky wheat and Canna Butter Chewy Fudge Brownies. Would this confuse you? And the question is, does it matter? I mean, the concern here, perhaps, especially with the Fritos and Lay's and Cheetos, is that this might confuse children, though I can't imagine that they could afford to buy this if they're coming in to buy Cheetos. But that's aside the point, right? If you are one of the trademark holders for these snacks, you might be very concerned about this use of your trademark and the confusion that might occur, the lack of control, and the association with something that you might not want to be associated with. Just one more example. There was a guy in Vermont. He was sort of a farmer and an entrepreneur who made these t-shirts, say, "Eat More Kale." And he got sued by Chick-fil-A, which contended that the phrase "Eat More Kale" infringed on its trademark, "Eat More Chicken." Now, Chick-fil-A demanded that this guy give his website to Chick-fil-A and stop selling "Eat More Kale" shirts. They wound up losing, but I just want to point out that there's a lot of this kind of litigation, and trademarks are only protected to the extent that they are associated with specific products. So a trademark holder has to be vigilant that their trademark doesn't get diluted and become generic. and become the word for things. Like Band-Aid started having ads saying Band-Aid brand, trying to emphasize that Band-Aid is not the generic word for that thing that you put over a cut, but is their specific thing that you put over a cut. Xerox had a very similar kind of a thing with copying, right? They wanted to make it clear that the word for making those copies is not Xeroxing, even though it gets used that way frequently, right? They were trying to protect their trademark. I might have just said copyright, but I meant trademark. I apologize. Okay, so there's some key issues in intellectual property, right? The two issues are, what can you actually own? And then when you own something, what rights does that give you? In terms of copyright, the question is something an original worth of authorship fixed in a medium? In terms of patent, right, is something useful, non-obvious, and novel? And in terms of trademark, when does a word or a symbol identify the source? Now, if you can satisfy one of those tests to have either a copyright or a patent or a trademark, what you get is a different set of rights. A patent is the right for 20 years to completely exclude anyone from using your thing without your permission, and you can either give that or require that it be purchased from you. A copyright, it gives you control for a much longer period of time, but there is an exception for fair use of the copyrighted work. And fair use could be in a news broadcast, it could be in a classroom, it could be a short excerpt that you are using to refer to something else. And importantly, parody has been found to be fair use. And then a trademark lasts as long as the trademark identifies the source. So there's no inherent time limit on it. And then something that doesn't satisfy those tests, or when the time has passed, it becomes part of the public domain, which you also can think about as the commons.